Thank you, Michael. And every time somebody pronounces my surname, they pronounce it a little bit differently. It's actually pronounced Houweling. So those of you who are Dutch should know how to pronounce that very well. This afternoon I want to speak on a topic that you may have read something about in the newspapers and seen on the media. It relates to the Swan Valley and the refusal for a place of worship to be established within the Swan Valley. I read in 1 Kings 6, in the 4th year, in the 480th year after the Israelites came out of Egypt, in the 4th year of Solomon's reign over Israel, in the month of Siv, the second month, he began to build the temple of the Lord. And in verse 14, so Solomon built the temple and completed it. What I don't read there is the applications to the Department of Environment, the applications made to planning institutions and authorities that would probably have rejected it, the applications of appeal to the State Administrative Tribunal or perhaps the Supreme Court, and other ways within which Solomon needed to get his temple built. In fact, what I do read is that he built a rather large building and he had the support of the people surrounding. They, in fact, provided a lot of the materials that were used to build that temple. If we were to try to build this establishment today, as beautiful as it may look, it would be objected to and opposed on all sorts of bases. One which would be its form and design. It's a big box. It would be objected to on an architectural basis. It would be objected to because I didn't see a lot of car parking around it. It would be objected to because they were slaughtering animals at the front. And it would be objected to because it was affecting the surrounding amenity of people living in a close proximity. However, about 500 years later, or thereabouts, it was destroyed. People from Babylon destroyed it. In the year later, the Israelites came back, they rebuilt it, and in the year 70 AD, again it was destroyed. And why was the focus on places of worship and the destruction of those places of worship? What was so important about destroying where the people of God were gathering together? Why was that the focus? And the focus is no different from what happens in China today. If you can prevent people from gathering together, if you can stop them from being able to assemble, if you can ensure that they don't come and express their faith in community, you're able to attack the central tenements of what is important to any faith. And that is the gathering together of people. So important is the opportunity for gathering together that it has received some focus in Australia in some articles. Now, I'm going to strain my eyes somewhat and read this for you because at the back of the room you wouldn't be able to. But in this particular article by Noel Villeman, who is a PhD and has written a number of articles, as well as written his PhD thesis on planning law within Australia, he said, the right of a religious community to establish and maintain places of worship is an integral component of the broader right to the freedom of religion or belief. A denial of the former means the infringement of the latter. And it's for that reason that it's important that we discuss this afternoon attempts by local governments throughout Western Australia to make places of worship a prohibited use within their town planning scheme. And it is only these minuscule things, these small things, that is the practical application of so much of what we were discussing this morning. This morning I see we've got a lot of theory. This afternoon I'm seeing a little bit of the practical application. The problem with making places of worship an ex-use within the town planning scheme is that it prevents places of worship from being built. Now, I can assure you that at first glance it appears to apply equally. And I want to discuss with you a little bit more about that by way of a real example of where this has occurred within Western Australia. It occurred within firstly the Shire of Mundaring In 2014, I argued a case on Coppin Road. The case involved the establishment of a place of worship. The case was going swimmingly well. So well that in fact one of the tribunal members, in my view a little bit infamously, but indicated that it was likely to one of the clients that their case would be okay, much to their relief. What occurred was that the Shire of Mundaring pushed through an amendment to their town planning scheme to make a place of worship an ex-use, meaning a prohibited use. We argued the case, we completed the argument, the decision was reserved, and we were waiting on the outcome of the argument, the decision to be made by the tribunal. During that 3-month window, an amendment was rushed through to make a place of worship in the rural areas, that particular rural area, a prohibited use. These people have been trying to establish a place of worship for in excess of about 5 or 10 years. It had the effect of meaning that the tribunal had no choice but to say that the place of worship could not be established on Coppin Road. I can tell you that there is also a case which involved the city of Gosnells, and they also, but the tribunal ruled for other reasons, were amending their town planning scheme so that within that particular zone, a place of worship would become a prohibited use. It received some attention within that particular judgment, but it ultimately was not the reason for why a place of worship was refused in that particular area. Religious freedom is a matter of central importance, not just to Christians, but to all faiths. It's an absolute freedom that we must enjoy and be seen to ensure that persons of all religions enjoy that freedom. And it's for that reason that no matter what the type of faith is, that it ought to enjoy the similar freedoms as other faiths, and the Christian faith in particular. I say that because the Christian faiths largely have had the opportunity of establishing themselves in the central business districts and central areas within Australia, but other persons who then seek to establish themselves, migrants who come to this country in the 50s, or perhaps migrants who have come into this country in the late 70s, 80s and 90s, who endeavour to establish their places of worship, can find it particularly difficult. And we might ask ourselves, what is really going on? Through a number of examples, I'm hoping to be able to convince you and satisfy you that there is a real focus on places of worship as being prohibited or being objectionable, as opposed to reasons that we would want to refuse the Tabernacle of Solomon. Big box style building, parking, amenity. Those types of issues which are often raised as reasons for why developments ought to be the subject of a refusal. This is 4 examples within the Swan Valley. On each one of these 4 examples, there was a recommendation by the officers, that is by the planning staff, that the application ought to be the subject of an approval. On each case, the council itself decided that it would oppose or refuse the application for development. Now, the question then arises is, what is really going on? In the case that I recently argued before the State Administrative Tribunal, incidentally in which we were successful, there was again an attempt to amend and change the town planning scheme while we were partway through the application before the tribunal. In fact, the night before we started our case in the tribunal, the City of Swan had endeavoured to put forward an amendment to its town planning scheme for the purposes of advertising at that point. Now, firstly, I want to take you to a 2014 application. I should tell you that within the Swan Valley, the stated concern is that there is a loss of vines, or that places of worship being approved would result in a loss of vines or an impact on vines. An impact so that vines could not establish, grow grapes and the like. Now, this is the first application, or one of the first ones that we reviewed quickly, and it was called the Chin Baptist Church in Suffolk Street, and you can see in the background, if you can look carefully, that it's in relative close proximity to Vines. It was, in 2014 still, the subject of an approval. An application by Dawodi Bahora made an application. It was the subject of a refusal, despite being probably equally distant from areas of vines. This is the application or the location which we dealt with very recently out of the State Administrative Tribunal. The red area is the area which we were dealing with for a place of worship known as RSSB, and I'll tell you a little bit about them briefly. But immediately behind, in the area that you can see in the front of the photograph at the very least, is an area which has been cleared and was going to be used for a major horse stud sale area. Parking of hundreds of cars all over the place. Large sheds, and if you go there today down Dale Road in the Swan Valley, you'll see just how monstrous the development is. What my clients were seeking to do was build a fairly modest-sized place of worship on the lot which is identified in red, which would only take a very small footprint of about 600 square metres, 700 square metres, and a car park and some ancillary other things such as a shed and the like. Now, looking at this, you would have to ask, why would the place of worship which had been proposed over the red lot be opposed, whereas I think it's the Harvey horse stud sale yards be approved? There was no logical reason why. That caused us to dig a little bit deeper. It also caused us to dig and find out precisely why was some applications for approval refused in the Swan Valley. Now, I hope, and certainly the next examples that I want to take you to are in respect of a mosque, but I hope that nobody would see that the reasons for why one group of people should enjoy the freedom of religion should not be equally applied to people who are of the Muslim faith. In looking through a number of the reasons for why places of worship were refused, there were reasons given in the council minutes, which stated things such as against terrorism, could be the focus of un-Australian behaviours. Not all Muslims are terrorists, but going from reports from overseas, including the UK, 70 to 80% support terrorists, and they lead from they are led from the mosque. So why do we need that in Swan? Things such as, why would Bosnia or any other religious persuasion want an area which was settled with many people from now Serbia, Croatia, the traditional enemies? Unfortunately, displaced people do bring their enemies with them. Now, that sort of reasoning, and it goes on. I mean, one submission I found a little bit funny. They said, why would they want to establish themselves within the Swan Valley? They don't even drink wine. I'm not kidding. And the West Australian, of course, had a bit of an article in which they said turning water into wine about all of what was going on in the Swan Valley. In any event, a number of very interesting reasons, all focused on refusing places of worship generally within the Swan Valley. Now, the application which I'd been dealing with out of the State Administrative Tribunal more recently was a place of worship. It was for a group of people who, broadly speaking, had come out of India, and they were described as a very peaceful religion. So they are a group of people who, for all intents and purposes, were peaceful. They were welcoming of other faiths. They didn't hold weddings, funerals, or baptisms, or spiritual services of any kind. There was no loud music that they were amplifying. They would hold one annual day a year, had a relatively small footprint, and their application would not result in the loss of any of the vines at all within the Swan Valley. Their services would be used for about 1 hour a week, and additionally the location would involve itself, or people would involve themselves with growing organic fruit on the lot. For all intents and purposes, one would say very unobjectionable to anybody who would be wanting to think about whether or not a place of worship should be approved or refused. But unfortunately, the application was refused. And what is telling about the reasons for why it was refused was that when I look across Australia at all of the other jurisdictions, the same reasons are used for why places of worship are refused in those other regions or in those other areas. For example, on the question of amenity. Now, the building was quite unassuming, certainly wasn't anywhere of a large size. Or another reason was given was the risk of spray drift, that there would be spraying activities of the vines and it would spray over onto the place of worship. Or the reason of traffic. And I'll pause here for a moment. Immediately over the road is Oakover Winery. Anybody who's been to the Swan Valley, who has toured around, you can go for a cup of coffee there, you can go to yoga there, you can go to a conference centre there. They have annual days of about 20,000 people who attend there, which turns the place rather into a circus. But yet, they, being the Oakover Winery, were objecting, and other persons were objecting to building this place of worship on this particular location, despite the fact that Oakover Winery was carrying out activities with a larger footprint than what this particular place of worship was. Lastly, there was the argument of preservation of rural character. Now, all of these reasons are usually given by the tribunal or alternatively planning authorities for refusing places of worship. There have been about 12 applications since about 2004, 12 applications for places of worship which have been refused by the local government, taken to the State Administrative Tribunal. Only 2 of those have in fact been successful. All of the others have been refused on the basis of these types of reasons: amenity, traffic, spray drift, those types of things. A lot of it relates to car parking, I might add. So what is going on? What are we looking at? Are we looking at a conscious decision to try to prevent places of worship from being able to be established? Now, I indicated to you that on the night before we commenced an application that the City of Swan proposed an amendment to its town planning scheme. Now, what you probably can't see on the screen because it's too far away, this is what we call a zoning table. And within the zoning table, you have different marks: D for discretionary use, A for a use which needs to be the subject of advertising, or an X use, which is a prohibited use. Now, I can tell you that from this particular scheme, there was a proposal to amend the scheme so that places of worship became an X use, meaning prohibited. Whereas things such as clubhouse, community purpose, or place of assembly all would remain and were discretionary uses. For those of you who can see this on the screen, the amendment is here. I'll just point to it. Where the place of worship is identified with an X. Now, these proposed amendments, which were going through the day before or the night before the commencement of the application to the State Administrative Tribunal, was focused on amending the town planning scheme, the effect of which the State Administrative Tribunal, if passed, would need to listen to the amendment. The Mayor of the day was reported in the community newspaper to say this: the decision proposes better regulation of land uses with the Swan Valley Rural Zone for the purpose of supporting traditional agricultural activities and protecting the rural character of the area. So we're going to make places of worship an X use. We're going to prohibit them within the Swan Valley Rural Zone because it is going to protect the rural character of the area. Now remember, keep in mind for a moment, I said to you that community uses, club purposes, and places of assembly as different uses were all going to be kept as discretionary uses. And I'll come to the definition of those in a moment. The Swan Valley is a beautiful, irreplaceable asset, and our priority is to enable viticulture, agriculture and horticultural traditions are upheld and preserved for the future generations. Now remember, the application that we were dealing with had nothing to do with removing not even 1 square metre of vines. Now, these matters came also to the attention of Aaron Stonehouse, sitting at the front, who indicated within Parliament that he would move to disallow the law as it's delegated legislation under the Interpretation Act. You can certainly do that. And he said, and was reported to say, bans like this have no place in modern Australia. If church isn't your thing, fine, don't go to one. But to pass a blanket law that prohibits other people from practising their faith is totalitarian in the worst possible sense. Now, I trust that the media properly represented what you had said there, Aaron. Now, bear in mind that my thesis within this presentation is focusing on this particular application and saying that it is evidence, in my view, of why local government, in the thin edge of the wedge, is able to pass legislation, its own town planning scheme, which has the effect of prohibiting places of worship. And keep firmly in your mind what Noel Vollerman said in the first slide, or the second slide that I put up, and that is that if you've got nowhere where you can practice religion, then you are giving lip service to the point that you say that we hold the freedom of religion. Then we do little more, or much the same, as what they do in China, and that is preventing people from gathering together to have places of worship so that they can come together. So am I too extreme? Okay. Club premises, community purpose and place of assembly are all separate uses. I said that each one of those were retained for the purposes of discretionary uses. The only use which was being made to be a prohibited use was a place of worship. So firstly, let's have a look at club premises for a moment, which is on the screen. It means a premises used by a legally constituted club or association or other body of persons united by a common interest. Tell me, what is the difference between people gathering together for the purposes of worship and a club premises? Let's have a look at another use which was retained as a discretionary use, community purpose. Means the use of a premises designed or adapted primarily for the provision of education, social or recreation facilities or services by organisations involved in activities for community benefit. Again, tell me, what possible impacts could there be created which are greater simply because you use a location for a place of worship? The next is a place of assembly. It means premises provided to people to assemble for a public activity. What do you do when you engage in worship? You engage in a public activity focused on worship. The only use that was being prohibited was a place of worship. Now look at the definition and I'll read it for you, and there's a central couple of words in here which make it different from a club premises, community purpose or a place of assembly. It means a premises used for religious activity. Aha! I found the point of difference. Such as a church, chapel, mosque, synagogue or temple. And that's the reason for why a place of worship must be so objectionable so that we make it an ex-use within the Swan Valley. Because after all, we're happy to have club premises with all the traffic that they generate, perhaps used on more days than just one day a week. We're happy to have a community purpose. We're happy to have a place of assembly. Don't get together for the purpose of religious activities. The justification was said to be from a number of other amendments that were being suggested to the scheme. Now, if you think for a moment that other commercial uses were able to be carried on, such as Moorish nuts, if you live in the Swan Valley, I'm just see some people pointing to this. Moorish nuts, they developed here. Vines at the rear, no vines anymore. they developed quite successfully for a commercial purpose and remove vines. But if you seek to establish a place of worship, even though you are seeking to establish it in a location where there are no vines, and there was expert opinion that there would be no impact on vines, and no impact on the rural amenity of the area, and no impact on the character of the area by experts, nevertheless, it justifies the passing of amendments to a scheme to try to prohibit the use. We can all get active and we can become members of your local government. I'm sure Peter Abetz would agree with that. To ensure that amendments and the erosion of what is permissible is not done by stealth. Thank you, ladies and gentlemen.